The heir in the Supreme Court chamber was charged with anticipation as justice. Amy Coney Barrett raised her voice to interrogate former Florida Attorney General Pam Bondi. What began as routine oral argument in Federation of States v. Department of Commerce swiftly escalated into a formidable intellectual contest. In that moment, Barrett, renowned for her meticulous textualism and calm demeanor, opened with a pointed reference to Harrington v. Davis, challenging Bondi's grasp of established Commerce Clause precedent. The court, hushed and expectant, braced for an exchange that would test the mettle of both jurist and advocate. Justice Barrett's credentials are impeccable. Confirmed to the court in October 2020, the former Notre Dame law professor and Seventh Circuit judge commands respect across ideological lines for her doctrinal rigor and incisive questioning. By contrast, Pam Bondi's reputation was forged in the crucible of Florida politics, the state's first female attorney general, 2011-2019, celebrated for a hard-nosed prosecutorial approach and political acumen, rather than academic nuance. Her selection to lead a coalition of 17 states in this high-stakes challenge to federal regulations surprised many observers who doubted her Supreme Court experience. At issue in Federation of States v. Department of Commerce was whether recent federal rules impermissibly intruded upon states' taxation and land use authority. A ruling in the state's favor promised a seismic shift in federalism doctrine, against the backdrop of a conservative majority willing to re-evaluate long-standing cases. Barrett viewed the opportunity to cement an originalist vision of state-federal relations. After Barrett's opening salvo, questioning Bondi's reliance on Harrington v. Davis and her Article 3 jurisdiction theory, Bondi responded without hesitation. She noted that Harrington survived scrutiny because it met the three-part test outlined in Justice Kavanaugh's controlling concurrence. Federal interest demonstrably outweighing state sovereignty, tailored action minimizing state administrative burdens, and demonstrable necessity. Barrett's posture straightened as Bondi then invoked Westmoreland Fist, United States, a 10th Circuit ruling later cited approvingly by this court in Montgomery v. Louisiana to illustrate the limits of federal reach. Bondi's command of the case law not only countered Barrett's critique, but reframed the terms of debate. When Barrett raised a challenge under Article 3, referencing Justice Scalia's dissent in Williamson County, Bondi traced the dissent's adoption in Nick v. Township of Scott, a decision effectively overruling Williamson on jurisdictional grounds. Barrett's tone shifted from dismissal to genuine curiosity as she asked whether Nick's property rights holding could extend to broader federalism disputes. Bondi's answer linked lower court expansions to this principle, demonstrating that the court's evolving jurisprudence supported her position. At this juncture, other justices joined the dialogue. Justices Thomas and Kagan posed follow-up inquiries, each met by Bondi's precise citations and case-specific distinctions. When Justice Alito referenced Texas v. Johnson, Bondi distinguished the free speech context from the structural federalism issues before the court. Barrett, no longer testing but listening, acknowledged Bondi's reasoning, even as she warned that adopting it wholesale might narrow the Denison framework that has guided federal-state regulatory boundaries for nearly a decade. Bondi countered thoughtfully, invoking Justice Gorsuch's majority opinion in Denison to argue that its general principles allow for tailored approaches in unique circumstances, exactly the scenario at hand. As the Chief Justice indicated that time was expiring, Bondi encapsulated her remaining points with the same clarity that had characterized her entire presentation. Rather than seeking an extension, Barrett surprised the room by requesting additional minutes, a procedural courtesy signaling deep engagement. The climax arrived with Barrett's hypothetical scenario, so intricate that it would later appear in constitutional law exams. Rather than falter, Bondi deconstructed it through 3 distinct constitutional principles, citing precedents authored by Barrett herself on the 7th Circuit. By the time Bondi referenced Justice Thomas's concurrence in Department of Revenue, Vastook, and reconciled it with the limitations of Freiriadman, the courtroom was enraptured. Justices leaned forward, clerks scanned transcripts, and even the Solicitor General adjusted his notes in anticipation of a more challenging adversary. Within hours, legal blogs and scholarly forums dissected the exchange. SCOTUS blog published a mid-argument analysis unprecedented in its depth, dubbing Bondi's performance a tour de force that reshaped federalism debate. So, constitutional law professors across the spectrum concurred, regardless of one's stance, Bondi's mastery of precedent and doctrinal history demanded respect. The phrase "appalling a Bondi" swiftly entered the lexicon to describe moments when an underestimated advocate upends expectations through sheer legal brilliance. 3 months later, in a 6-3 decision, the court vindicated the states. Justice Gorsuch's majority opinion adopted significant elements of the framework Bondi advanced in oral argument, while Justice Barrett issued a concurring opinion engaging directly with Bondi's analysis of her own prior rulings. Such explicit acknowledgement of an advocate's influence on constitutional doctrine remains exceedingly rare. The repercussions for Bondi were immediate. Prestigious law firms recruited her for their Supreme Court teams, and leading universities extended visiting scholar invitations to have students learn from her approach to constitutional advocacy. Meanwhile, Barrett's reputation for intellectual humility was reinforced. In a later Federalist Society panel, she lauded the exchange as proof that assumptions can be challenged by advocates from unexpected perspectives, underscoring that judicial integrity demands openness to persuasion. In the end, the Barrett-Bondi confrontation transcended partisan labels and personal histories. It became a testament to the vitality of constitutional discourse when advocate and jurist engage rigorously and in good faith. The Bondi test, the 3-part standard she articulated, now guides lower courts in evaluating federal regulations that affect traditional state functions. More broadly, their encounter serves as enduring proof that the greatest strides in constitutional law emerge not from unyielding adherence to preconceived notions, but from the willingness to interrogate, refine, and transcend them. In the months that followed, the reverberations of the Barrett-Bondi exchange continued to shape constitutional practice and pedagogy. At elite advocacy workshops, instructors replayed the argument's pivotal moments, urging participants to emulate Bondi's methodical blend of doctrinal depth and strategic narrative. Law school clinics, long focused on mastering oral advocacy skills, redesigned their curricula to include transcripts of the hearing, setting the Bondi standard as the aspirational benchmark for every student's brief and oral presentation. Simultaneously, professional organizations for appellate lawyers noted a marked increase in female participation at Supreme Court preparation seminars. Several leading moot court competitions introduced an award in Bondi's name, recognizing the competitor who best demonstrates rigorous legal research coupled with composure under cross-examination. Likewise, bar associations organized panel discussions on intellectual humility, citing Barrett's willingness to extend Bondi extra time as emblematic of the ideal judicial temperament, one that prizes open-minded engagement over adversarial posturing. In the corridors of power, the case's impact rippled outward. State attorneys general in quiescent jurisdictions found renewed confidence to challenge federal overreach, leveraging the 3-part test articulated at the oral argument into new petitions. Within 3 federal circuits, judges began citing the Bondi framework in decisions addressing regulatory disputes, an acknowledgement that oral advocacy, when impeccably executed, can precipitate tangible doctrinal shifts well before a written opinion issues. The Federalist Society and its liberal counterpart, the American Constitution Society, jointly honored both Barrett and Bondi at their annual gala, underscoring that principled dialogue transcends partisan alignment. In their keynote address, Barrett reflected on the hearing as a clarifying moment that reaffirms our institution's capacity for self-correction through rigorous challenge. Bondi, in her remarks, stressed that attorneys carry the responsibility not merely to persuade, but to elevate the conversation, ensuring that foundational principles of federalism are understood and preserved beyond institutions. The public narrative evolved as well. Mainstream news outlets ran profiles on both women, Barrett as the intellectual force reshaping modern textualism, and Bondi as the advocate whose meticulous preparation redefined expectations for state challengers. Editorials lauded the hearing as proof that the highest courts thrive when advocates present complex arguments in accessible, yet analytically robust terms, reminding lay audiences that constitutional questions are not arcane puzzles, but living debates with real-world consequences. Ultimately, the Barrett-Bondi encounter became a case study in mutual respect and professional excellence. It illustrated how thorough preparation, command of precedent, and poised delivery can transform an advocate's perceived limitations into defining strengths, while reminding jurists that their probing questions, when met with unexpected expertise, can spark new avenues of legal thought. The lasting lesson was clear. Genuine progress in constitutional jurisprudence emerges from the intersection of adversarial rigor and collaborative insight, ensuring that America's foundational law remains both resilient and responsive to fresh perspectives.